Thank you. Okay, members, we're going to reconvene after our lunch break. And for the record, K3B, we didn't finish that item, so we're going to table that until after the next item. If I can get Ms. Taylor to call the next item.
Yes. The next item is AA, COVID-19 County Boards of Equalization Assessment Appeals Boards Collaborative Work Group Consensus Guidance, Letters to Assessors on AAB Hearings. Additional items presented by Member Vasquez and Member Cohen. This includes an update and presentation of the work group's findings and recommendations for discussion and possible board action on additional items. New sub-issues include 1. Developing efficiencies around scheduling and scheduling mechanisms. 2. Establishing a meet and confer process. And 3. Offering pre-hearing conferences.
Okay. Members, we will discuss and try to reach consensus on 3 additional items vetted at our November 18th meeting. You received a memo dated December 11th suggesting options reflecting prior discussions on each. These are intended as a starting point. If we end up with an issue where no consensus is reached, we will revisit it when the work group is ready next month or defer to an interested parties process. To facilitate this, I will ask Ms. Taylor to announce each issue and read the option in the December 11th memo into the record. I will call on each work group participant to state how they would suggest changing it. When it appears we are close to an agreement, I will ask Member Cohen's deputy, Regina Evans, to identify possible consensus language or other agreements. I will then call for the motion from the board and vote on any motions that are presented. With that, let me turn it over to Member Cohen if she has any opening remarks.
Yes, thank you very much. I don't have.
You're muted. We can't hear you.
Thank you very much. I said I don't have any opening remarks. I think we'll just go ahead and jump in and get started.
Thank you. With that, if I can get Ms. Taylor to begin the process here.
Certainly. Our first issue is issue 1, developing efficiencies around scheduling and scheduling mechanisms. The current AAAB manual and LTA number 2013/039, Effective Administrative Practices Assessment Appeals Process, do not provide guidance regarding the scheduling of remote hearings. 3 options are suggested. Option 1, consider allowing local flexibility as suggested in the following statements and encourage clerks to contact BOE with concerns regarding the scheduling of remote hearings based on its clearinghouse role. The board recognizes the balance between the need for statewide uniformity and county flexibility to meet local needs in conducting remote hearings, subject to the application of existing rules to remote hearing procedures and to the practice of mirroring in-person hearings to the extent possible when conducting remote hearings. Accordingly, if a remote hearing is scheduled, the clerk must provide notices to all parties informing them of the remote hearing access instructions, coaching or training videos, staff, consultation, and special needs accommodations. To assist counties administering remote hearings, the BOE is serving as a clearinghouse for purposes of addressing questions and providing specific guidance, and may be contacted at BOE Property Tax Department at 916-274-3350. Option 2, consider advising clerks to inform applicants that they may withdraw an application as early as possible if they do not intend to proceed, consistent with the Assessment Appeals Manual, page 35, withdrawal of an application, and LTA number 2013/039. Generally, an applicant can withdraw an application at any time prior to a hearing, including a remote hearing. In some counties, however, if the assessor has indicated that evidence to support a higher value will be introduced at the hearing, the applicant will not be allowed to withdraw the application without concurrence of the assessor. Counties that use this process must have a local rule allowing such a procedure. If an applicant withdraws an application that has also been designated as a claim for refund, the applicant should be advised that the withdrawal of the application will also constitute withdrawal of the claim for refund. Clerks should inform applicants to withdraw their application at the earliest possible date if they do not intend to proceed with the hearing, so that their scheduled time can be given to others as available dates and county resources are limited. Option 3. Consider advising clerks to remind applicants of the requirement to comply with RTC Section 441D requests before a hearing, consistent with guidance in AAB Manual, page 39, on Section 441, Information from Taxpayer Records, and LTA number 2020/033, Amendment to the Appeals Manual, Postponements and Continuances. Clerks should remind applicants that Section 441D requires a taxpayer to make available to the assessor for assessment purposes information or records regarding the taxpayer's property or any other personal property located on premises the taxpayer owns or controls. The assessor may obtain details of property acquisition transactions, construction and development costs, rental income, and other data relevant to an estimate of value, and it may be introduced at an appeals board hearing. Taxpayers are expected to comply with an assessor's reasonable requests, as both the assessor and the taxpayer must be able to use and present the same information at hearings. If a taxpayer fails to provide information to the assessor under Section 441D and introduces any of it at a hearing, the assessor may request and will be granted a continuance for a reasonable time. Section 441D applies regardless of whether or not an appeal has been filed.
Thank you, Ms. Taylor. Will the speakers representing the AABs please address issue number 1? And would you please state which option, either 1, 2, or 3, that you're addressing so that we can keep an accurate record? Who do we have on the line from the assessors?
Mr. Chairman, this is Thomas Parker from Los Angeles County.
Yes, welcome.
Yes, Los Angeles County is fine with option 1 and option 2 and with option 3.
Thank you. Who do we have? Who's representing the assessors?
Yeah, Chair Vasquez, this is Don Gakel, Stanislaus County Assessor and President of the CAA. Yes, I agree. The CAA would be fine with all options 1, 2, and 3 under issue 1.
Thank you. Who do we have from the taxpayers online?
Good afternoon, Chairman. This is Brian Rabowski on behalf of CADA. And welcome. I would like to address, thank you. I would like to address each of the options that have been laid out in the BOE's memo. By and large, CADA is in agreement with each of the 3 options, but I did want to make some comments on each of them. So with respect to option number 1, we certainly agree with respect to remote hearings that flexibility is needed. It should mirror in-person hearings to the extent possible. The notices of hearings are incredibly important, and the BOE should be operating as a clearinghouse. However, on the issue of notices, we thought it would be helpful to require that the counties include within their notice of hearing, which is required under Rule 307, within 45 days of the hearing unless stipulated to a shorter time, the information that's listed here. So specifically, it's stating that notices should inform all parties of the remote hearing access instructions, coaching or training videos, staff consultation, and special needs accommodations. We think it's incredibly important that that information be provided along with the notice of hearing to give parties, especially small taxpayers, the ability to understand and even test the remote hearing process for themselves. It is a really new concept to a number of different taxpayers, especially those that are unrepresented. And in many cases, we found that counties, as they're rolling out remote hearings, are only providing information specific to remote hearings, days, maybe 10 days before the hearing. And it simply doesn't allow enough time for the taxpayers, whether represented or unrepresented, to understand the process that they're going to be engaging in. So here we'd request that the notice and the information that I've read out to you be provided along with a notice subject to the timing requirements under existing Rule 307. Also under Issue 1, Option 1, we note that it only relates to remote hearings as drafted, and we think that there are definitely scheduling concerns related to in-person hearings that need to be discussed. And so we would like, rather than spend a significant portion of today trying to focus on the needs of scheduling efficiencies, we would prefer to discuss that at the January hearing. It is a topic that should be addressed, in-person hearings, and how we better improve those scheduling efficiencies. So we'd ask the board to take up that issue as part of the next agenda. For purposes of Option 2 related to withdrawals, we agree that it's, certainly reminding folks that withdrawals and early withdrawals, to the extent they are aware they will be withdrawing, are certainly appropriate. We also wanted to suggest, consistent with some of the language in LTA 2013-039 at page 2, that the use of confirmation notices for hearing may be helpful. We've heard folks from the assessor's office as well as the clerk's office express frustration when taxpayers, quote unquote, no-show for hearings. So everybody's prepared for hearing and a taxpayer simply doesn't show up to the hearing. I think we all recognize on all sides of the table that that doesn't help anybody and really clogs up the system. So a number of different counties have implemented a confirmation of hearing process where, along with the notice of hearing, they will attach a confirmation notice, and in most cases require that that confirmation be submitted back to the clerk within 21 days of hearing. If the confirmation notice is not returned timely, then often cases the hearing is postponed or will not move forward because the hearing wasn't confirmed. And in that case, you save the counties a lot of effort in not preparing for a hearing that won't go forward. So we wanted to highlight that to the board and to the county as a potential option of ways to also alleviate the concerns related to no-shows. And then with respect to option number 3, on the 441D information request coming from the county, I think we're also in agreement that that reminder is appropriate. The only thing that we would say is the option number 3 is drafted, focuses solely on information requests coming from the assessor's office under Revenue and Taxation Code Section 441D. To me, it seems imbalanced to only focus on information requests coming from one side. There are also equal information request options under Revenue and Taxation Code 408 for taxpayers to collect information from assessors' offices. And we think it's important that this be altered to balance and include a discussion of Revenue and Taxation Code 408 and the appropriateness of those information requests, and encouraging counties to respond to those requests, just as taxpayers are being encouraged to respond to reasonable assessor requests. And I think you'll find that that's consistent with Assessment Appeals Manual at page 39, where you see not only a discussion of Revenue and Taxation Code 441D, but also a discussion of Revenue and Taxation Code 408. So I trust that that could be quickly revised by BOE staff and member staff to include a discussion of 408. Thank you for your time.
Thank you. Is Ms. Evans on the line?
I'm not sure if
Mr.
she's on the
Vasquez,
line.
I am on the line.
Yes. Okay. Now, given the comments we heard, I mean, it looks like there's obviously a consensus with at least the assessors and the AIB, but taxpayers, if I'm hearing this correctly, they're generally on board, but have some concerns. Am I reading this right?
Mr. Vasquez, I'm just wondering, are we going to hear from the other work group members before we
Yes.
conclude in regards to the position of the parties on the work group related to
Yes.
consensus?
Yes, yes. Do we have them on the line now?
I believe, I'm not sure, but we have Marcy Berkman, we have Jennifer Tran, we have Marvis Mazik, Kathy McCullen. Not sure, we haven't heard from them unless I missed them.
No, you're correct. I haven't heard if they're on the line. I'm hoping they're on the line.
Mr. Chair and board members, this is Thomas Parker.
Yes,
Ms.
go ahead.
Tran was not available for what's turning out to be the entire meeting. I will speak on her behalf on the practical end in part of what Kata says. The confirmation notices about the upcoming appearances of applicants at hearings, that issue has been examined certainly in Los Angeles County, and as a practical matter, that system, which I understand has worked well in some other counties, from what I've heard in the past, is not really going to work in Los Angeles. I hate to always be the voice of Los Angeles is different or special or unique, and I apologize if I sound like a broken record on points like that. But I just want to make sure the board knows Los Angeles County AAB has looked at that, and we have found that that system is not going to help streamline the Los Angeles County system. It's going to clog it up further. So if the board is interested in adding that consideration into whatever it decides to do, we would respectfully request that the board be sure to recognize that it is not a mandatory element of an assessment appeals board program, and that it's got to work given the realities of the particular jurisdiction. Thank you very much.
Thank you. Is Marcy Berkman available? How about Kathy McCullen? Or Masillan, I think it is. What about, am I hearing somebody back there? How about Kathy McCullen? Well, we're getting a real delay here. I'm hearing some background noise
Hi,
here.
this is Marcy Berkman. We had some technical difficulties with the operator connecting me in.
Okay, go ahead. Welcome, Marcy.
Thank you. I had to call in a couple of times to get
Sorry about that.
No, not at all. Thank you very much for allowing me to participate. With respect to issue one, option one, on behalf of Santa Clara County, I am fine with that. On behalf of option two, I have no problem with having the clerks remind people that they can withdraw as soon as possible. I would suggest that possibly there's also some public outreach that the State Board of Equalization could do, and particularly to agents, because I think the largest span of issues, at least in Santa Clara County, we have with those is agents and professional in-house tax people as well, who file protective applications and then don't really do their due diligence until shortly before the hearing to figure out whether or not they really have an appeal and file at the last minute. And in Santa Clara County, what we often experience is agents will even be withdrawing on the last day. So while the clerk can perform some outreach, it would be fantastic if the State Board of Equalization also could do some outreach on that as well. With respect to Ms. Rabowski's comments about the confirmation forms, we do use that in Santa Clara County. I believe the State Board of Equalization's Assessment Appeal Manual recommends usage of that hearing notice procedure, the confirmation that you're going to attend the hearing. I'm not sure if there was once an LTA on it or not, but I do know that the State Board officially endorses longstanding that procedure and encourages each county to have a local rule addressing it. I would note that even so in Santa Clara County, we probably have between 10 and 30 people at each hearing who have not returned the form that we briefly dispose of through the denial for lack of appearance if they don't show up at the hearing. And 3 or 4 people, maybe 5 each hearing, who don't return the form and show up and then need to be set a new hearing date. So that does help with the situation in those counties for which it works, but it doesn't completely alleviate the situation. But it does help in terms of the assessor does not need to prepare for the hearing if the response form is not received. I should probably comment that every so often we have some applicants who are really upset that they either didn't read the information soon enough and didn't complete the form and send it in, or they sent it in and it got delayed in the mail, or they claim they sent it in and they're not happy that when they come in they need to get a new hearing date. But it is a helpful solution, and we have found it very useful in Santa Clara County. With respect to option 3 on 441D, while the clerks can certainly remind applicants to comply with 441D in order to get their hearing date set, and I know in Santa Clara County we have a 441D noncompliance calendar, and when applicants are on that calendar and the board tells them how long will it take before you can get those documents to the assessor, and assessor, if they do that, what date will you be ready for appeal? And the board member, the board chair at that point, then reminds the applicant that this is subject to their actually getting the documents done in a timely fashion. One thing that occurs to me that would also be useful is at CADA's request a year or 2 ago, the State Board of Equalization did a Form 441D letter that took effect this year. And perhaps the State Board of Equalization could put together an insert that would be included with that form, reminding applicants that unless they are compliant with the 440D1 request, that it's going to hold up their hearing. And that would be a simple way, because the clerks are not involved in the 441D process. That's between the assessors and the applicants. And in most counties, there's no involvement by the clerk at all in that. In Santa Clara County, we have the 441D noncompliance calendar, so it at least comes up then. But since the State Board of Equalization already has a Form 441D letter it put together, I think it would be fantastic if they could include with that, a form notice that you're required to provide this to get your hearing, and not doing so is going to hold up your hearing date. Thank you very much.
Thank you.
Oh, one more thing. I'm sorry.
Sure, go ahead.
Going back, Kata made a comment about option 1. with regard to the timing, requesting that the board include the information regarding remote hearings in the notice letter, and requesting that the SBE require this to be 45 days before the hearing. One thing that I'd like to point out is your first hearing notice is sent out 45 days before the hearing. But under the existing rules, if a hearing is continued, there only needs to be 10 days of written notice. And so I don't know how it's working in the counties that are conducting remote hearings, because our county is not, but it might potentially be that that 10 days written notice was because the hearing was continued. And continued hearings only require 10 days written notice. However, I do concur with Kata that, if you know at the time you send out the hearing notice, the hearing is going to be remote, then that should be put in the hearing notice. And I would caution that, especially with counties going in and out of different pandemic restrictions, that there may be circumstances where a hearing is originally scheduled to be live and then the county converts it closer to the hearing date to a remote hearing in order to protect the public. Thank you.
Thank you. I know Mrs. Tran is not available, but is it Marvis, looks like Nasik? From San Diego? I wonder if they're having problems connecting as well. And how about Kathy McSeelan from Sacramento? Ms. Taylor, do we know if AT&T is having a problem connecting them?
No, at this time, I believe that Ms. McClellan had an emergency, so would not be able to join. And let me check with the team. AT&T, is there anyone on the public line that might be one of our invited guests?
Please press 1, then 0. Looks like we do have one line that's queued up here. One moment.
Can you hear me?
Yes, go ahead.
This is John McKibben on behalf of the California Association of Clerks and Election Officials. I apologize. Several of our key members had conflicts today, and I guess we're unable to attend after all. I just had one comment, which Tom Parker also touched upon, and that has to do with the confirmation form. The clerks have been discussing that form for many, many years, and there's no agreement on whether or not that would fit well into local processes. Some of the experiences have using the form have been successful, others have not been successful, and have created, in many instances, or in some instances, I should say, more confusion than that procedure merited. So the reason why it's in limited use today, I think statewide, is that the clerks have looked at it and for the most part have decided not to adopt that procedure, since it does create more time, more demands rather on the clerk's time, and sometimes for not much benefit.
Thank you. And it looks like I don't think we have anybody else on the line for this one. Is that correct?
This is Ryan with AT&T. I do have Karen Dursey that queued up here. One moment. Her line is now open.
Okay, go ahead.
Good afternoon, members. This is Kareem Dreesi with the California Association of Realtors. And I do apologize, members. I was experiencing some technical difficulties, so I'm not sure if this is the most opportune time to state this, but just wanted to briefly thank the members sincerely for their engagement on the Prop 19 implementation issue. We very much appreciate the continued engagement with the BOE and with BOE staff, and wanted to assure members that we are proactively working with the assessors as well as the California professional firefighters in trying to reach consensus on follow-up legislation, and certainly look forward to working, continuing to work with the BOE on that issue. And certainly if there are any working groups or if we can be a resource to the BOE, please feel free to call upon us. So just wanted to take this opportunity, and I hope it's appropriate, just to thank the members for their continued engagement on the Prop 19 implementation issue. Thank you so much.
Thank you. Going back to the County Assessment Appeals Board's representatives, is there anybody else that we're missing here? Hearing and seeing none at this point, let me go back to our staff. Ms. Evans, are you still on the line?
I am, Mr. Vasquez.
Was there anybody else that we were missing here? I think we got them all. That I know there was some emergencies there. Looks like we missed a couple speakers are not going to be able to join us.
I think you've covered everyone.
Okay. What are your thoughts moving forward on this one?
Just want to say to the work group what I've captured in the options, and just we would like feedback from everyone as it relates to whether I captured the consensus properly. For option 1, it appears that the language as written is acceptable. The one request centered around the language that refers to hearing access instructions, coaching or training videos, staff consultation, and special needs accommodation. There is a request that in the drafting of whatever guidance we provide, that we specifically state that that information is included in the notice when possible. Want to just make sure from all parties that that is what everyone is agreeing to.
This is Thomas Parker for Los Angeles. Yes.
Marcy Berkman, yes.
This is Brian Rabowski from CADA. I think that is generally accurate. The thing that I will say is when you add on when possible, I think that applies to the list of things that are provided here. However, I do think the fact that the hearing will be remote as opposed to in person must be included within the hearing notice. So that one particular fact that it will be remote, I think must be included within the notice, because each of the rules, Rule 307, as well as Rule 323 that talk about notices of hearing, require that the clerk provide a notice of hearing of both the time and place of the hearing. So to my mind, the requirement that you be noticed of the place would be the requirement that you be noticed that it will be remote. So I think, again, the idea that it's remote must be included within the hearing notice, and these other items that are listed here regarding access instructions and training, so on and so forth. You know, we highly encourage that it be included at the same time of the notice of hearing, but using your language of whenever available could be sufficient.
Brianna,
Thank
this is
you,
Marcy
Mrs. Robowski.
One question for CADA's representative. If, for example, a live hearing after being noticed was subsequently converted to a remote hearing, would it be CADA's position that notice is improper and the hearing cannot go forward and that the date needs to be continued to a different date?
I think that would be something that would be subject to waiver. So certainly if it got converted to a remote hearing and that wasn't agreeable to either party, I think there would be a notice problem. But certainly under either rule, if the parties agree, they can waive that notice time frame. So I would suggest that would be something subject to party agreement through waiver.
I'm wondering to the work group members if we want to give the latitude to the board to direct board staff when they are drafting the language associated with this consensus item to consider the discussion that we just had, trying to be sensitive to the fact that I think it was Ms. Berkman that pointed out that sometimes a hearing is noticed based on a 45-day notice, subsequent continuances occur, or even the example that Ms. Berkman just made. And instead of us trying to draft that language in this discussion, that we would allow staff to be sensitive to the variables that you have pointed out and draft language that meets those issues. Are we comfortable with that?
Los Angeles, yes. Los Angeles, yes.
Others?
Don Gackel, CAA, yes. Acceptable.
John McKibben, CA CEO, yes.
And Ms. Berkman and Ms. Robowski.
Marcy Berkman, yes.
Brianne Rabowski on behalf of CADA. Yes, I think that's agreeable. I think we just want to make sure it's underscored that this process is brand new for folks. So getting this information out to them, especially those who aren't represented, is absolutely critical. And I think much like, for example, I just received a notice of remote hearing in San Francisco County, and they have a boilerplate set of sort of instructions that allow you to understand what you should expect as part of the remote hearing. We are contemplating something much the same. So we're expecting, something like a small leaflet that explains how remote hearings are done in a particular county. So the hope is, as remote hearings become more and more part of our typical process, it won't be difficult for county clerks to provide such a leaflet with the notices of hearing. So with those understandings and recognizing that it really does place many taxpayers at a disadvantage to receive that information late, I think having board staff and member staff look at our timing concerns is appropriate. So we are in agreement.
Thank you. Option 2, I think as it relates to consensus and certainly need feedback from the work group, that we are accepting the language as drafted. There was a recommendation by one of the work group members that maybe the Board of Equalization could engage in some outreach, just period, in this space. But overall, I think the consensus centers around language as drafted. Feedback from the work group.
Los Angeles agrees.
Santa Clara County agrees.
CAA agrees.
CA CEO agrees.
CADA agrees.
Thank you. Option 3, I'm not sure if I captured this appropriately. There was a recommendation from, I believe, CADA, that this option was drafted with a focus on 441D and was asking that we consider 408. And so I want to say to the other work group members, addressing the balancing issue that has been raised by CADA, are you all comfortable with giving staff the latitude to incorporate 408 in this section as drafted, and would like feedback from all parties.
This is Santa Clara County. I'm comfortable with the latitude, though I'd like to point out that hundreds, if not thousands, of cases a year in Santa Clara County are held up by 441D noncompliance, and we might end up with a hearing requested to be continued on 408 grounds once a year or once every couple of years. So it's really the 441D noncompliance that creates the hearing scheduling problem.
Los Angeles concurs with what Santa Clara said.
CA CEO is generally in agreement with Santa Clara. I'm a little concerned that it might cause some confusion, but I'll defer to people with more expertise than I on that point.
This is Don Gakel, CAA. I guess we have no issue with the requirement that's listed in statute being repeated. So we generally do not have an issue, but we don't have an issue with adding that. We also agree with Santa Clara that we don't think that that's a large issue generally, but that's fine, adding that language. You're leaving it up to the staff to determine.
Thank you. I want to say,
Ms. Evans, if I might just add something, this is Brianne Rabowski on behalf of CADA. The sensitivity around 408 is the idea that we're asking clerks to remind applicants, both large, small, represented, and unrepresented, of the requirement that you respond to information requests. If we're going to be reminding folks that they have this obligation, it seems important, especially for those who are unrepresented and likely very unfamiliar with the property tax process, that they be notified that they have a right to collect the assessor's assessment information as well. I've found that unrepresented taxpayers, smaller taxpayers, don't often know that they have that right because they aren't well versed in the process or the surrounding law. So when we are reminding them of their obligations, it seems only fair that we also remind them of their ability to collect information in advance of hearing.
This is Marcy Berkman from Santa Clara County. I would suggest that perhaps the State Board of Equalization and maybe CADA could conduct pro bono outreach to unrepresented applicants in that regard. However, what this issue is about is the timeliness in scheduling hearings, not making suggestions to applicants that, hey, these are the ways you can make document requests. There's 408 for certain information from the assessor and 1606 for the formal exchange process. The issue here is around scheduling and the fact that frequently hearings are delayed and calendars left with positions that cannot be backfilled because applicants, and in particular those represented by attorneys and agents rather than, say, for example, self-represented homeowners, have not complied with 441D requests. And while the clerks and the appeals board certainly can remind them of their obligation on that, again, clerks are not part of the 441D process. That goes back and forth between assessors and applicants. And in only some counties have pre-hearing procedures, and Santa Clara County may be the only one that has a 441D noncompliance calendar where the board can address it. So again, I'd like to suggest the option that, an insert be included or a page with the Form 441D letter that the assessor sends out, reminding applicants that in order to have their hearing scheduled as timely as possible, they need to get their information in response to the 441D, because not doing that will hold up the scheduling of their hearing. And that way it would ensure that each person who gets a 441D letter really understands, hey, make sure you get this back in, timely in order to get your hearing scheduled as fast as possible.
thank you. I have one question to Ms. Berkman and Mr. Parker. It sounded as if everyone else felt like just reiterating 408 potentially in the LTA was acceptable. Just want to make sure that I'm hearing from the two of you that it's not acceptable.
Los Angeles, Ms. Evans, this is Thomas Parker of Los Angeles. We are acquiescing. We are acquiescing. It's very, I'm not going to say never, but it's very rare in Los Angeles with all of our appeals and all of our comparatively big value appeals where 408 is an issue. So it's, while we are acquiescing for sake of consensus, it's an additional element in search of a problem to some degree, but notwithstanding that, LA doesn't want to stand in the way of consensus on this item.
This is Marcy Berkman, Santa Clara County. I agree that the statute references continuances for noncompliance with 408, and therefore, on a hypothetical notion, I have no problem with it being included in the LTA. But again, it has been a complete non-issue in Santa Clara County. It is almost never that a hearing is held up due to 408 noncompliance. And I think the 2 times that I can remember a hearing being delayed, it wasn't even really delayed. The assessor's case went in, and then there was a little bit of information applicant had, and applicant asked for another time period to go over that information, and that was granted. And the instances in which I can recall it coming up, most often it's extraordinarily sophisticated tax agents and tax attorneys like, Chuck Mole, or someone like Ms. Rybowski, who are the people who engage in that. There may have been, in all my years, perhaps one self-represented taxpayer who asked for a postponement due to 408 noncompliance. But generally, on this very, very, very rare occasion it comes up, it is in a very large, very sophisticated case, like an assessment of a stadium or an arena or something like that. So it's not something that has created scheduling issues, I think, in Santa Clara County or around the state. And so while I hypothetically have no problem with referencing it in LTA, it's also not something that's causing a scheduling problem. And, if you want to educate self-represented taxpayers about the availability of 408 as a tool, or the availability of 1606 and 305.1 formal exchanges as a tool, I think public outreach, via, CADA conducting pro bono seminars, or the state board doing that on educating taxpayers or putting out materials, is probably a better way to do it than issuing an LTA. Your self-represented taxpayers aren't going to be reading the LTAs anyway.
So, Ms. Evans, this is Brianne Rybowski from CADA. I just wanted to make a couple of comments in response. I think part of what's occurring here is we have fantastic insight on behalf of LA County and Santa Clara County, but we're missing insight from a lot of other counties. And I can tell you from personal experience that there are issues with 408 responses. And in fact, I have had issues with 408 responses in LA County in particular. But setting those aside, my point is they are issues that exist. They are issues that exist and hold up scheduling for large hearings in particular, as Ms. Berkman has pointed out. The other point that I wanted to make is if we are to include an addition to, I guess the point is if we're going to be reminding applicants, whether it's in an LTA or it's not really specified in what manner clerks should be reminding applicants in the language that we're looking at here. But presumably, if that's included as part of the notice of hearing or otherwise, I think it's fundamentally unfair, whether it's related to scheduling or otherwise, to only point out an obligation to respond and not an ability to collect information. So I think, it's just an important point to keep in mind, the ultimate fairness of the communications that are going out.
Certainly appreciate all the feedback. For purposes of consensus, it seems like the language for option 3 as drafted is what the work group is definitely agreeing to. I will say, Mr. Vasquez, this might be an issue that the board may want to revisit in a different venue. But for consensus purposes, I think we only have consensus as drafted.
I think you're correct. I'm sorry, go ahead. I heard somebody else.
I was just going to clarify, Brianna Rabowski on behalf of CADA. I actually thought that we had heard others acquiescing for purposes of consensus, that there be parallel language in 408. Was I incorrect in that? And I know that there was a lot of discussion around that and the need for that. However, I did thought that I had heard a consensus.
This is Thomas Parker from Los Angeles. As I said a few minutes ago, we were acquiescing to some kind of staff drafted reference to 408 for the sake of consensus. I wanted to make sure that the state board was aware of our view completely. But as I will say again, we are willing to acquiesce to and give state staff latitude to draft a reference to 408 in order to achieve consensus.
Yes, I heard that from Mr. Parker, but I'm not sure if I heard that from Ms. Berkman, so maybe we could have Marcy clarify the record.
I will also acquiesce reluctantly.
Okay, so Mr. Chair, that is the language as accepted by all parties on all 3 options.
Thank you. We're making some progress here. Ms. Taylor, would you call the next option we have here? Or actually, next issue, I guess it is.
Chairman Vasquez, Deputy Controller Stowers.
Yes, go ahead, Ms. Stowers.
I'm sorry, before we go into the next issue 2 on this item, is the goal to direct the ED on some of these for each issue based on the consensus?
Yes.
If so, that's the goal. Are we going to do the direction after we resolve all 3, or are you going to give direction per issue?
I was trying to do it at the end, but we could do it after each one. What's your preference?
I don't have a preference at the end or after each issue. I just want to say and restate what I said yesterday, that whatever we decide upon, I would really appreciate a motion as opposed to a directive. I just wanted to put that out there now.
I'm good with that.
So this is clear what we're asking our ED to do.
Yes. I was just trying to take or respect the time of the folks that are online and try to get them in. And then we have a little more time afterwards to kind of flush things out if people are okay with that.
I'm definitely okay with that.
Thank you. Ms. Taylor.
Our second issue is issue 2. Consider establishing a meet and confer process. The current AAB manual does not provide guidance on a meet and confer process. Option 1 for LTA guidance. Consider providing the following statement to encourage informal discussion between the parties before a hearing if a county does not have a formal meet and confer process. For an appeals hearing, whether remote or in person, to be most effective and the process to be most efficient, taxpayers and assessors should provide each other and the AAB members with comprehensive information regarding the subject property and the taxpayers and the assessor's opinions of value for the subject property. There are various means and opportunities for informal discussion between taxpayer and the assessor to obtain pertinent information for the hearing, which can help them narrow and resolve issues before a hearing and thereby reduce the time commitment involved. As a result of such discussions, many appeals are resolved by by a stipulation as to value between the parties per RTC section 1607. If a county has a formal meet and confer process, the parties may consider using this method for an early resolution of the issues.
Thank you, Ms. Taylor. Will the speakers representing the AAB please address this issue as suggested by the option?
This is Thomas Parker from Los Angeles, Mr. Chairman and board members. We are in agreement with the option 1 language for issue 2 that's just been read.
Thank you. Who do we have from the assessor still?
This is Don Gakel, Stanislaus County Assessor, CAA President. As I said in my written communication with to the board, I think that this is by and large duplicative of guidance already given under pre-hearing conferences and established practices already in assessment manuals and in board guidance. But in the end, I think it should be left up to individual county assessment appeals boards to determine. As we agree with the statement in there that in the option that says that there are plenty of opportunities for assessors and taxpayers to interact and share information and work towards stipulations. We just don't think a formal meet and confer process is required statewide or would be necessary in most counties in the state.
Thank you. Do we have Ms. Grabowski on the line as well still?
Yes, this is Brianna Rabowski on behalf of CADA. I think generally speaking, the language that's included within the BOE memo certainly is agreeable to us. I think there's definitely a lot of value in reminding the parties of the ability to informally meet and the potential for discussions. A couple ideas we had about how to sort of better leverage the willingness of certainly some counties to meet with folks is to include a statement about informal discussions and the openness of those discussions, either in the notice of hearing or in some communication so that folks know that that's available to them. One of the other practical problems we have is, especially in large counties, it is not uncommon for your appeal to be moved from appraiser to appraiser to appraiser. And so oftentimes what happens in large counties is you don't know who it is that you're supposed to contact. And it can take you, honestly, it can take you months to figure out the right person to contact about your appeal so that you could even start to try and schedule a substantive discussion on the appeal issues. So if there's some way to have the designated person you should be speaking with for your appeal somehow communicated to the taxpayers, I think that would be a massive improvement in large counties in particular. I acknowledge that's not going to be a huge issue in the smaller, perhaps even the medium-sized counties. Some of the other things that we think have worked well in taking a broader look at what do a lot of different counties do. Orange County has a model by which they have a division between their audit and standard appraisers and then their appeals unit. So they have a separate appeals unit dedicated to appeals. For us, we have found that that means it's much easier to understand who it is you should be discussing your case with. It often means that they're working your appeal much more proactively and are dedicated to meeting with you to discuss your appeal. So, you know, I just sort of note that that's something that we commend and is something that should be studied and looked at by other counties. I think there are other counties that proactively work appeals. San Diego does a fantastic job in my experience and the experience of many others. So I think by and large, I actually take, after looking at all the different letters that were written by the CAA, by the CA CEO, and Assessor Larry Stone out of Santa Clara County, I actually take some hope. And I know that that might be sort of a strange thing, but some hope that there is some common ground upon which we can build. I think everybody would agree that no procedure is perfect, even if informal discussions are happening sporadically among some parties. It is always prudent, regardless of the type of procedure, to take a step back and look and ask yourself what's working, what isn't working, how do we improve upon this? And that's really our request here, is let's study this process. Let's see if there's something we can do to learn from the places where these informal discussions are happening and are working, and spread it across the state. The other reason I take hope is when you look at the letters and the responses that were provided to the BOE, I think there's a lot of misconception about what it is CADA is requesting. And so I think when you have an understanding about what we're requesting, we're actually much closer to having something we can work with than you would think. So a couple points of misconception are, we are not suggesting that our quote unquote meet and confer like procedure be mandated upon anybody. We are not saying it should be required. We are saying that much like a pre-hearing process, it should be in the menu of options of things that are used as a best practices and can be picked up by the counties and implemented by the counties if they see fit and as appropriate. I think the other thing is, it's not appropriate for all cases. If we were to try to implement this across every single case in any one county, I would guess that it would clog up the system. So certainly there is certain types of cases where this works best, and that's left up to the counties and the clerks to decide. So I think there's certainly an openness there. The idea that this is cookie cutter doesn't work for anybody. I think also we need to be very clear that our recommendation is not that the board members be involved in any way. These are private meetings that we're suggesting between the taxpayer and the assessor. We are not suggesting that any substantive or evidentiary information be provided to the board members whatsoever. I think there's a great concern out there that we color the perception of board members or allow them to prejudge the evidence. I recognize that that risk is there. However, I don't think that that's a reason to throw away this idea. I think there are many, many things that can be done to tailor around that. So for example, when we talk about the forms that we're suggesting, when we say a high level, discussion of the issues that will need to be heard for hearing, those can be converted into check boxes, much like many of the BOE forms that exist. They can, check the boxes if the income approach is in contention and if there's a discount rate issue. Certainly ideas that we can develop upon, but we can certainly tailor around this consideration. And then finally, I think it's the idea about the form and whether or not a form is needed. Again, we are sort of looking to create a quote unquote best practices model that can be used and studied by counties. We are not saying that a county must use a form. We are simply saying in our observation is when we think about this, we think that there are great benefits to having a form that's submitted to the board. I think there's a lot of learning that can come out of that. And then finally, I think of note, we are very appreciative of the CA CEO and their openness to work on this issue. I think, like I said, it is incredibly imprudent to study all procedures, always, to see if they can be improved upon. And then finally, I wanted to say, in terms of sort of formalizing or creating this best practices meet and confer like procedure, I think there are many, many benefits to both sides. So some of the benefits that I think really are helpful to everybody is obviously it's encouraging the flow of information between parties. We've also heard a lot from the counties and the clerks, their frustration about no-shows and protective appeals. Certainly, this process can be used as a tool by the clerks and the boards to ferret out those who are filing appeals that don't have any intention of moving forward with them or intend to, allow a hearing date to pass without appearing. I think this really could be used by counties proactively in a way that would be very beneficial in that regard. I think it's also helpful in many cases. A lot of times in large and medium-sized counties, you'll have an appeal. I personally have several that are pending right now. It's a simple mistake. Somebody made a mistake. They didn't read the reporting right. Something happened, and I am confident that once we get the right person's attention, the issue can be resolved. So you have, certain instances in which you have mistakes that don't warrant any board effort or board time that could quickly be dealt with once you have the parties coming together. Obviously, we have the narrowing of issues. So we heard a lot of concern about this is going to cause extra time, this is going to cause extra effort, this is only adding more to everybody's plates. However, I think by taking a case that appears to be, huge set of appeals or even a modest set of appeals and getting on the table exactly what issues you contest and what issues you agree with really streamlines the back end of this case. It streamlines what has to be heard by the board and really removes what is currently a black box approach by both parties, where oftentimes, not always, oftentimes you go to a hearing not knowing what the other side's going to say. That leads to much longer hearings, much more preparation by both sides than is ever needed. So to me, even though it's intimidating and it's a new process, and I recognize there is a general resistance to new processes, typically, that's a human reaction, investing the time on the front end of cases and truly taking the time to build a best practices that allows people to meet and encourages people to meet will save so much time on the back end of these cases that you will ultimately end up with clerks that have more time because they have better efficiently running calendars, better scheduling, and boards that have more time for actual evidentiary hearings of substance because they aren't dealing with these no-shows and these other things or issues that are not under contention. And so for all of those reasons, we think that it's important to keep this discussion going. We think there is value to creating this best practices model. And we do, again, say that it isn't something that would be mandated or cookie cutter on any county in particular. And I recognize that was long. Thank you for bearing with me.
Thank you. Okay, let's, do we still have Marcy Berkman online?
Yes, this is Marcy Berkman from Santa Clara County. My concern with option one, as written on the board's memo, is it seems like there's a focus on informal information exchanges rather than on the broader scope of both substance and procedure. And I'm also very concerned about the should in the first sentence. In Santa Clara County, it's not uncommon, and if the first self-represented taxpayer of the day does it, then everyone seems to follow suit. Well, after the assessor presents their case, say, well, this is the first time I'm hearing any of this, and I want a continuance, at which point we tell them, no, that this is your hearing day, just as we would if the applicant had gone first, and then the assessor just wanted a continuance for the heck of it. And my concern, based on years of experience with listening to that, and the self-represented taxpayers can really get all up in arms over this, is as an attorney, as a layperson reading this first sentence, it says you should provide each other your opinion of value and all of your information. And I can see that really turning into a fight at hearings of the should and whether somebody did or not, even though there are already rules in place that govern formal exchanges and informal exchanges, 408, 441D, 1601, 305.1, that all govern it. And so that first sentence concerns me. What I would be comfortable with would be something that starts with the second sentence and says there are various means and opportunities, et cetera, and encourages, and I would use the term encourages, applicants and assessors to get together as early as possible to discuss all aspects, substantive and procedural of the case, and then goes on to the rest of it. And so that you're encouraging them to participate in that process. As noted in the letter that we submitted, and I appreciate that it's not part of the guidance here, but I'll address it because Ms. Rabowski did. We do not think any sort of form should be submitted to the appeals board or the clerks unless that particular county has enacted a local rule either allowing or mandating the submission of such a form. And I think that pretty much covers my thoughts on that. Thank you very much.
Thank you. Is there anybody else from the Assessment Appeals Board representatives here?
Mr. Chairman, this is John McKibben.
Oh, yes, go ahead.
So I don't know if I should be speaking now or waiting until a later public comment period.
No, go ahead
I'll
if you
defer
have
to you,
something.
Chair.
If you have something,
Yeah,
go ahead.
Yeah, generally, we have no serious problem with option one. We tend to have the same feelings as Marcy Berkman expressed with regard to the first sentence, but generally, for a very long time, clerks have always tried to get the parties to speak to each other well ahead of the hearing, preferably even before filing an appeal, as we've testified in some of your previous hearings. Generally, otherwise, I think we're in agreement with option one as written. However, I would hope that it would be tweaked a bit as well to just make it clear that even in the county that doesn't have a formal meet and confer process, the parties are expected or should talk to each other prior to the hearing when and where possible. So that it doesn't require that nobody comes away from reading this with the notion that since there's no formal structure, we don't really need to talk to each other, if you follow. That really is all the conclusion of my remarks on this point.
Thank you. Before I move it on or pass it on to Ms. Evans, I just wanted to check with Ms. Taylor on the first item, issue one. I forgot to check with you to see if there was anybody on the AT&T public line wanting to speak on that.
Okay. Well, we did open the line and we did have a speaker come on from the realtors.
That's what I thought. Was that it?
That was it.
Okay. And we don't have any written comment on that one, right?
We do not.
Okay. Just wanted to double check. All right. Let me pass it back on to Ms. Evans.
Chair Vasquez, if I capture the sentiments of the work group, there appears to be consensus about encouraging discussions between the parties, whether there is a formal meet and confer process in place or not. And it seems like it might make most sense that staff take the issues raised by the parties on the work group and draft language similar to what's here, but more of a focus on encouraging that communication for purposes of addressing the issues as captured in this paragraph, and also just reinforcing whether it's a formal process or not, labeled as meet and confer. But I think we can give the staff the latitude to move in that direction. And just want to hear from the parties if that's the overall consensus.
This is Tom Parker from Los Angeles. We're comfortable with what you've just said, Ms. Evans.
Thank you.
Santa Clara County concurs.
CAA is, I'm sorry. the Don Gakel CAA, we are comfortable with BOE staff interpreting the discussion today and coming back with a recommendation.
CADA is likewise in agreement.
Thank you.
I think that was
John
it, right?
McKibben on behalf.
Oh, go ahead.
I'm sorry, John McKibben on behalf of CA CEO. We're very comfortable with Ms. Evans doing as she proposes.
Thank you. Anybody else? I think we got everybody now.
Mr. Chairman, this is Brianna Rabowski again on behalf of CADA. I think, we raised many issues that go well beyond the language that's drafted here that we've now reached a consensus with some tweaking on. So I would just sort of ask if there is a plan to take up that issue. Again, we note in the CA CEO's letter, they're open to some of these ideas. I do think that there is common ground that could be explored even by those that have submitted some letters of concern and opposition. I do think there is an open door to be explored here, and I'm curious what that may look like and what board engagement that may call for.
Thank you. Anybody else? Hearing no one else, then Ms. Evans, I think we're clear to move on, no?
Yes, Mr. Vasquez, I think in your communication to the board, you did state if there were issues that needed continued discussion, that there is the possibility for the board to consider moving certain items to the interested parties process. And maybe if parties agree, this might be one of those areas if we want further development of the issue.
Correct. I think you're right. With that, let me have Ms. Taylor move on to issue number 3.
Our third issue is issue 3, offering pre-hearing conferences. Option 1, encourage use of pre-hearing conferences where appropriate. The following option is consistent with Rule 305.2, AAB Manual, page 38, pre-hearing conferences, and LTA number 2013/039, effective administrative practices, assessment appeals process regarding stipulation documents. The board encourages county boards of supervisors to use their authority under Property Tax Rule 305.2 to establish pre-hearing conferences as appropriate to meet their needs, and if established, to adopt procedures for holding pre-hearing conferences either in person or remotely, as these conferences can be a valuable tool in the orderly scheduling and conduct of AAB and county board hearings. Such conferences are usually appropriate for hearings that will consume more than one day of appeals board time and may be set by the clerk at a time convenient to the taxpayer and assessor. The conference may be conducted remotely and may deal with a variety of subjects, including but not limited to application validity, bifurcation of hearings, time estimates, resolution on non-controversial factual or valuation issues, outline of basic legal and/or valuation issues to the appeals board, stipulations, status of requests for information, and calendaring of the full hearing on the issues. Pre-hearing conferences are an option for all counties and have been shown to save considerable time and expense for the appeals board as well as the parties. They are most helpful in minimizing the need for the parties to request continuances of hearings that are unilaterally set by the clerk. In addition, or as an alternative, if the assessor and the applicant resolve the disputed issues, RTC section 1607 provides that a written stipulation may be submitted to the board as provided in LTA number 2013/039.
Thank you. With that, let me ask the speakers representing the AAB if they would please comment on this option.
This is Thomas Parker from Los Angeles. The only change Los Angeles would request the board consider is in the first paragraph, last sentence, replacing the word usually with often. Otherwise, we are in agreement with the language just read.
This is Marcy Bookman, Santa Clara County. I confer with Los Angeles' suggested change. In addition, in the second, where was it? Which paragraph? Sorry. At the end, additionally, at the end of that first paragraph, there's an ambiguity in that same sentence. That sentence says such conferences are usually are often appropriate for hearings that will consume more than one day of appeals board time and may be set by the clerk at a time convenient to the taxpayer and assessor. In the way that sentence is framed, there's an ambiguity of whether the pre-hearing conference is set at a mutually convenient time or whether the pre-conference is being used to set a mutually convenient time for the valuation hearing. I think that the intent is for it to set the hearing date on the merits for a mutually convenient time, but it could be read either way. And to the extent it can be read and would be read as saying the pre-hearing conferences should be at a mutually convenient time, that just gets unworkable because it gets to be so hard to schedule times with everyone. Although I will note that in Santa Clara County, often at a 441D noncompliance hearing or a pre-hearing conference or a board consideration matter, we set the hearing for a future pre-hearing conference, and when that happens, we do choose mutually convenient dates. But I wouldn't want the suggestion to be that every pre-hearing conference needs to be scheduled for a mutually convenient date rather than just having the clerk of the board set one. And then the final change that I would suggest is in the final paragraph. It currently reads, "They are most helpful in minimizing the need for the parties to request continuance of hearings that are unilaterally set by the clerk." That sort of, I don't know, feels to me derogatory to the clerk and the AAB. And I would suggest potentially changing that to "they are helpful in scheduling hearings for mutually convenient dates."
Thank you. Do we have?
Mr. Vasquez,
Yes, go ahead.
may I ask Ms. Berkman a question?
Sure, go ahead.
Ms. Berkman, your first recommendation related to the ambiguity at the end of the first paragraph as you characterized it. Is it your recommendation that this refers to the hearing date as it relates to the merit of the case or the pre-hearing conference for clarification?
The sentence as it currently reads, I couldn't tell whether the intent of the sentence was for the merits hearing to be set for a mutually convenient date, or the intent of the sentence was saying that pre-hearing conferences need to be scheduled on a mutually convenient date. And my suggestion would be that if the language is included in this paragraph at all, it referred to scheduling multi-day hearings for a mutually convenient date, or lengthy hearings, or scheduling hearings for a mutually convenient date. However, that language is already in paragraph 3, so it might just be that we can end the sentence after the word time. You know, so either say such conferences are usually appropriate for hearings that will consume more than one day of the appeals board's time, and end it there, or you could say, and also for scheduling hearings on the merits for a mutually convenient date.
Thank you.
Thank you.
who else do we have on the line here?
This is Brianne Rabowski on behalf of CADA. I think
Yes.
I generally agree with all of the comments that have been made, especially Ms. Berkman's last suggestion, which is focused again on the first paragraph, the last sentence. I believe her second alternative was after "and" to say something along the lines of, and also for scheduling a mutually convenient time for hearing, or I didn't quite capture her language. Hopefully, perhaps Ms. Evans has. But as Ms. Berkman stated her suggested revision, that struck me as a good suggestion. So I would vote for that particular alternative, and otherwise am in agreement with the other suggested changes that have been made, as well as the existing language with those changes.
Thank you. Is Marcy on the line? Marcy Berkman?
I am. I've already provided my input unless the board has any further questions. Thank you.
Oh, sorry. Thank you. Are we missing it? I think we have. Is there anybody I'm missing?
Yeah, this is Don Gakel, the
Oh, Don.
CAA.
Go ahead.
Yeah, we're in agreement with it and have no issues with the changes suggested by Mr. Parker and Ms. Berkman. We would support that.
Thank you.
Mr. Chairman, John McKibben on behalf of CAA CEO, we agree with the changes that have been agreed upon by the other parties.
Thank you.
And for the record, this is Tom Parker from Los Angeles. I agree with the additional edits of Ms. Berkman of Santa Clara. Thank you.
Thank you. Ms. Evans, I think that's it, no?
I may have missed it, maybe public comment on this one.
You're right. And actually, I was going to ask Ms. Taylor when I asked her earlier, when I think we were referring to issue the item number 1, but I guess it's probably appropriate to now let's at least ask AT&T if there's anybody on the line on any one of the 3 now, whether it's the item 1, 2, or 3.
Thank you. AT&T moderator, do we have any public comments on any of these 3 matters?
Ladies and gentlemen, if you'd like to make a comment, please press 1, then 0 at this time. 1, 0. And we have no one queuing up for comment.
Thank you. So I think that wraps it up, Ms. Evans, no?
Yes.
So do you want to give it a shot in terms of summarizing all 3 now?
Do you want me to summarize issue 3 first, just to make sure I got that right?
Yes, please.
On issue 3, first paragraph, line 5, change usually to often, and put a period after time in the second to the last sentence, and delete the rest of that sentence. The other suggested change, and Ms. Berkman, please follow me closely. If you go to the last paragraph on page 4, line 3, after helpful, insert in scheduling hearings for mutually agreed upon time, and delete the rest of that sentence. Just want to make sure that's what you were recommending.
Could you read the new language one more time?
They are most helpful in scheduling hearings for a mutually agreed upon time.
I might suggest changing that to for a mutually convenient date and time. And I might additionally suggest striking the word most, since while they are indeed extremely useful for scheduling mutually convenient hearing dates, they're also equally useful for many other things, and I would not like to decrease the significance of the other things for which pre-hearing conferences are also important.
Perfect. I'll read the new sentence as I have it drafted. They are helpful in scheduling hearings for a mutually convenient date and time.
Yes, thank you very much.
No problem. With those two edits, just would like to get feedback from the work group.
Don Gakel, I agree.
Thomas Parker, Los Angeles, I agree.
Marcy Berkman, Santa Clara County, I agree.
Brianne Rabowski on behalf of CADA, we're in agreement.
John McKibben on behalf of CACEO, we're in agreement.
Thank you.
So I think we have a consensus on that one. Is that correct, Ms. Evans?
Yes.
Okay. Let's see if we can put this all together in one motion here. I'm thinking of those things that we captured as consensus, so staff knows what we're moving and approved as opposed to any direction here. Are we able to capture all three, Ms. Evans, here?
Certainly can make an effort, but if you're comfortable, would like to pose a question to the Chief Counsel and the Executive Director.
Yes.
Mr. Nanjo and Ms. Fleming, based on the summary that I captured after each issue, are you comfortable with the board moving forward with a motion consistent with those summaries?
This is Brenda Fleming. Yes, we are. I would concur. This is Henry Nancher, Chief Counsel.
So, Mr. Vasquez, I think the motion is just whatever action you want the board to take consistent with the summaries that have been previously captured for issue 1, issue 2, and issue 3.
Okay, I will go ahead and make that motion if there's a second.
Vice Chair Schaefer, I would second that.
Okay.
Point
So
of
we have,
clarification, Deputy Controller
yes,
Stowers. Point of
yes, Ms.
clarification.
Stowers, go ahead.
Can you give me a narrative on what your motion is, please, sir? By issue?
By issue? Okay, I'm going to have Ms. Evans read it back in what the changes were for each one, starting with number 1 to 3.
Mr. Nanjo, I'm hoping you can help here. I think Ms. Stowers is just asking for the motion, not the rereading of the narrative.
Let me clarify. It's going to be helpful for me for I can have it so I can really have an accurate vote and know what I'm voting on. If I can have a motion per issue, because I may not want to adopt each issue.
Okay, why don't we start, since the most recent, number 3, is fresh in our mind, why don't we start with number 3, because that one had some language changed that was made just in the actual recommendation.
Okay, let me help you out here, sir. I make a motion for item number 3.
Okay.
To adopt the language in issue 3, option 1, with the suggested changes as by from the clerk in Santa Clara County as agreed by the work group.
All right, I will go ahead and second that, so we at least have that one. Any comments, questions, suggestions? Seeing and hearing none, let me get Ms. Taylor to take a roll call vote on that one.
Before we begin, didn't we have a motion on the floor already that might need to be rescinded?
Oh, you're right. You're right. Because Mr. Schaefer, I will rescind my original motion, which encompassed all three, so we allow us to go through each one separately.
I would rescind my second so that we have clear sailing.
Great. Thank you very much.
Thank you, Ms. Taylor. All right. Now we'll go back to, we're just voting on this last issue 3.
Would you like me to restate the motion?
Sure, go ahead so people know what they're voting on.
I move to adopt the language in issue 3, option 1, with the suggested changes from the clerk in Santa Clara County as agreed upon by the work group.
And I second that, so let's go ahead and get a roll call vote on that.
Chairman Vasquez.
Aye.
Vice Chair Schaefer.
Aye.
Member Gaines. Member Cohen.
Aye.
Deputy Controller Stowers.
Aye.
So that's a 4. So we do have a majority that moves forward. Now we'll go back to issue number 2. I'm sorry, did I hear somebody back there? Going back now to issue number 2, Ms. Evans, if you could just kind of summarize what there was a consensus on, and we'll move that as a motion.
Yes, sir. There was a consensus for issue 2 to conceptually request BOE staff to provide guidance that encouraged all parties to meet before the hearing, as well as for those counties that have a meet and confer process to leverage those processes as it relates to assessment appeals matters. And there was a lot of discussion around how to achieve that, and staff would use that discussion in providing their guidance.
I will move that if there's a second.
Vice Chair Schaefer, I'd second that.
Objection.
Ms. Stowers, go ahead.
As was stated previously, I feel like this guidance is duplicate of what we currently have, so I'll be voting no on that motion.
Okay. Any other comments or questions? Hearing none, if we can get Ms. Taylor to call the roll on this one.
Chairman Vasquez.
Aye.
Vice Chair Schaefer.
Aye.
Member Gaines. Member Cohen.
Aye.
Deputy Controller Stowers.
No.
So we do have a majority, so it was a 3-1 on that. So that will move forward. And for issue number 1, I would like to just move that we accept the recommendations of the summary as read by Mrs. Evans. And if Evans, and if Ms. Stowers, if you need that to be repeated, we will have it repeated.
I'm okay with it as she stated earlier.
Okay. So I will move that. Is there a second on that?
Vice Chair Schaefer, I second it.
Okay. Seeing and hearing no other comments, can we get a roll call vote on this one?
Chairman Vasquez,
Aye.
Vice Chair Schaefer,
Aye.
thank you. Member Gaines, not present. Member Cohen,
Aye.
Deputy Controller Stowers.
Aye.
Okay, so that was a 4. We got 4 votes on that, so that also moves forward. With that, members, we will go back and see if we can finish what we tabled earlier, and that was K3B. If I can get Ms. Taylor to read that back, and we'll see if we can't conclude that item.
All right, let me just reread the item. We are returning to item K, 3B, other administrative matters, the property tax deputy director's report by Mr. David Young on the analysis of the implementation planning of Proposition 19, the home protection for seniors, severely disabled families, and victims of wildfire or natural disasters act of 2020.
Okay, members, we kind of left this one where we were trying to figure out one, how quick we can turn around another meeting. So I was going to suggest that we have Ms. Stowers and Ms. Cohen, since we have that one working group already up and running, to work with our executive director, Brenda, and see if we can get at least do some of the legwork here as we prepare for I guess it looks like the earliest meeting we could possibly have in January, maybe January the 13th. Well, and I'm proposing that maybe we combine our January meeting that normally would be scheduled at the end of the month. I believe it's like the 26th. So now we could have it on the 13th and the 14th. So one, we'd be able to cover Prop 19 issues and recommendations and possibly some legislation that we can get in front of the legislators here in the middle of January as they come back together. Let me ask Brenda, the staff, Ms. Felmings, if that's something doable, because I know we're pushing back, and we're going to ask you to come up. I guess we need to probably have it posted to the PAN by the end of the month. Is that correct?
Yes, sir. This is Brenda Fleming. Yeah, so at this point, what we are looking at is in lieu of a January 26th, 27th board meeting, we could reschedule the January meeting to January 14th, 15th. That would push us to a PAN deadline with holidays, et cetera. That will push the PAN deadline to December 31st. So we would be working expeditiously over the next few days to get all of the PAN organized. So we'll work on getting that done. Starting then on the 14th and 15th, and I would note that the 14th and 15th would be Thursday, Friday members would be the time frame. And we could potentially dedicate one full day of that January meeting, the 14th or the 15th, to the Prop 19. That would allow BOE staff along with CAA to collaborate and come up with the course of action with a little bit more of concepts for the legislative proposals.
Members, are we all comfortable with that schedule?
I have no problem with it. This is Vice Chair Schaefer.
Thank you. Anybody else?
This is Deputy Controller Stowers. I'm perfectly okay with that schedule, with BOE staff working closely with CAA.
Thank you. Anybody else?
I don't believe it's a problem for me, but should a problem or conflict arise, I'll notify the executive director immediately.
Thank you. Ms. Fleming, do we need a formal motion for this, or is that understood?
Yes, we should use a formal motion because we're actually changing the board date, which was identified on the work plan for 2021, that we're making adjustment to the meeting date.
Okay, I will go ahead and move that we reschedule our January meeting now to take place on January 13th or the 14th, with one of those days being dedicated to follow up on Prop 19.
I would second that, Member Schaefer here.
Okay, so it's a moved and second. Is there any questions or comments on that?
Chairman Vasquez, this is Council Henry Nanjo.
Yes.
Ms. Fleming was suggesting the 14th and 15th. Your motion is for the 13th and 14th. I just want to make sure we know which date we're moving it to. If the meeting is the 13th and 14th, then Pan would be due the 30th of December.
Right. So what I'm proposing is, thank you, Henry. So what I'm proposing, Chairman Vasquez, is January 14th and 15th, which would be Thursday and Friday.
Okay.
And deadline then would be December 31st.
That works for me. I was just thinking that I was trying to move it up more so we wouldn't do the Friday, but that works for me. And given the time constraints, that gives you an extra day, I guess. So let me amend that. So it now reads, I'm not looking at a calendar, but I guess we're looking at 14th, 15th, right?
January 14th and 15th. The 14th is a Thursday and the 15th is the Friday.
Okay. So I will go ahead and amend that. So now it reads, we're moving it to the 14th and the 15th.
Vice Chair Schaefer, I would second the amendment.
Discussion?
Oh, I'm sorry. Go ahead, Ms. Stowers.
Thank you. So if we go with the 14th and the 15th, the Pan will have to come out on the 31st, which is an actual work day. And Ms. Fleming, your staff is available between now and the 31st to meet, confer, and get a Pan out with all the required attachments?
That will be our priority between now and December 25th.
Between now and December 25th, between now and next week. Okay,
Yes,
just want to make sure that you're clear on what you're committing to.
I'm clear on what we're committing to, but in being sensitive to members, just for your edification, when you're looking at the legislative calendar, the bill introduction deadline to submit proposed legislation to the Office of Legislative Counsel is January 22nd. And so in order for us to achieve our objective, which we've agreed on and discussed today, in order to achieve that January 22nd submission date, we do need to have the board meeting, have the discussion decision so that we have time to get your input and finalize our work before it would be submitted.
Okay,
So
unfortunately,
we do have a constraint with holidays and then deadlines. So it's going to be challenging. Absolutely will be challenging, but I have an amazing team, and we will work together and do our best to get it done. And for the public record, thanks to staff. I acknowledge them now. Thank you.
Thank you. And thank you for that clarification, Ms. Stowers.
Then I'm prepared to vote on the motion.
Okay. If there's no other comments or questions, then Ms. Davis or Ms. Taylor, if you could go ahead and call the roll on.
Chairman Vasquez,
Aye.
Vice Chair Schaefer,
Aye.
Member Gaines, Member Cohen,
Aye.
Deputy Controller Stowers.
Aye.
Oh, I'm sorry, I was muted there. So that's unanimous of those voting. We will go ahead and, you know what, I would just, Ms. Fleming, I just had on the previous motion we made, as it referred to the consensus items. Is it understood that we're going to put together an LTA for that, or is that a separate motion we need?
So may I ask staff to restate what the motion was? Mr. Nangio, if you're available online to restate the motion.
It was my understanding that, well, we had 3 different motions. I didn't have each one of them written down, but it was my understanding, to answer the chairman's question, that we were going to draft an LTA with those elements included in it.
That's what I thought. I just wanted to be clear.
Yeah.
Okay.
Thank you,
So
Chairman.
everybody.
Thank you, Ms. Fleming.
Thank you. With that, we can move on to the next item, Ms. Taylor.
Our next item is N, public comment on matters not on the agenda. Persons who wish to address the Board of Equalization regarding items not on the agenda may do so under this item on the agenda. Please note that the board cannot take action on the items not on the agenda. However, the board can schedule issues raised by the public for consideration at future meetings. AT&T moderator, could you please ask the public for comments? If there are any public comments, the AT&T moderator will open the line for your public comment.
And once again, if you would like to make public comment, please press 1, then 0 at this time. 1, 0. And we have no one queuing up for comment.
Thank you. With that, as we come to a close on today's meeting, I just wanted to make some quick comments, and I know we have some other announcements that people want to make before we adjourn, but I just wanted to publicly thank the staff and all of the members for bearing with us. I know this was a tough last 2 days, especially on these consensus items, and actually give a special thanks to Miss Evans, if she's still on the line, for participating and giving us the summation. I know that sometimes it's very challenging when we're doing it on the spot and pretty much live. So I appreciate your input and your participation with that. And I believe it was Mr. Schaefer that might have some closing remarks.
Thank you, Chair Vasquez. I'd like to adjourn our meetings in celebrations or memories where appropriate and significant. Today is the 81st birthday of Pope Francis, who is one of the leading figures in today's world and bringing peace to all. And I would just like to acknowledge that and wish him a happy 84th. Thank you.
Chair Vasquez.
Yes. I hear
this is Don Gakel. I'm sorry to interrupt Member Schaefer's closing thoughts, but I did want to say, although my work as president of the CAA is not done for this year apparently, but this will be my last public meeting with the board as CAA president, and I wanted to acknowledge that it has been an interesting year, and we've interacted a lot, and I appreciated my opportunity to represent the CAA before the Board of Equalization, and I'm not. I'll still probably interact with you for the CAA in some capacity in the future, but this will be my goodbye as president of the CAA to the board. So. Thank you, and good luck next year.
Thank you. I didn't realize this was your last meeting. I thought we were going to at least see you via Zoom or virtually here in January, but no, I wanted to thank you.
I'll probably be participating, but I won't be president then. So,
so you'll officially pass the gavel, I guess, already.
Vice Chair Schaefer, Don, I'd like to also thank you for your year of service. I thought we'd be seeing you at a Christmas party, but we're not able to do that. So this is my occasion to thank you for your good humor and your being with us so strongly.
Well, thank you.
And actually, let me say to you and staff and the members, wishing everybody a happy holiday season here. This will be our last meeting before we come back to the new year. And given these times with the pandemic and this COVID, I know it's difficult for any of us to interact or to even to get together, but just wanted to wish everybody safe and happy holidays. And as we adjourn, like to also adjourn in memory of all the lives we keep, hearing more and more people are coming to an end or dying from this COVID-19. I just got a text earlier that here in LA County, we've actually dropped down to 0 availability of beds in the ICU. So this thing, it doesn't seem to be getting better. It seems to be getting worse still. And I think part of it was because people were traveling and getting together during the Thanksgiving holidays. And I hope people will refrain from gathering during these holidays coming up, whether it's Christmas, Hanukkah, Kwanzaa, or whatever we celebrate these days, to hopefully try to bring this to an end. Thank you all. Unless there's any other closing remarks or comments, we will officially
Chairman
adjourn
Vasquez,
this.
if I may?
Yes, go ahead, Ms.
Brenda
Fleming.
Thank you, sir. So on behalf of the agency staff and my office, I just want to wish you all a safe and happy, blessed holiday. I thank you all for all that you've done in this amazing year called 2020. My prayers is that we don't continue this for too much longer into 21, and that we see some sunshine at the end of this tunnel. I want to also acknowledge President Gakel, Don Gakel. Thank you so much for your partnership over this last year. It's been tremendous, and you've been there by my side so many times in so many ways, and so I appreciate you and all the assessors within CAA who've partnered with us. I'd like to thank the staff, too, for just an incredible year and for what they continue to do to make sure that we're carrying out the important work of this agency. And again, to each of you members, I wish you a happy holiday and thank you for all of your support. It's a pleasure working with you all. Thank you so much.
No, thank you. And please thank your staff, because I know sometimes we overburden them as we choose to take on more and more responsibilities here, but hopefully they understand that it's all in the best interest of the taxpayer. Thank you. And with that, I'm looking at, I have, looks like 3:38. We'll officially adjourn this meeting. Thank you all. Be safe, and we'll see you next year.
Happy holidays, everyone.
Happy holidays.
Thank you, staff.
Happy holidays.